Here we go. Welcome, everybody, to episode 34 of This Week in FCPA. With me in person, as always, is Tom Fox. Tom, as everybody knows, is the author of the FCPA Compliance and Ethics blog at tfoxlaw.wordpress.com. I am Howard Sklar. I am senior counsel with software company Recomind, and I blog at Forbes at blogs.forbes.com/Howard Sklar and at OpenAirBlog at openairblog.com. Hello, Tom.
Greetings from our temporary DC studio. It's nice to be in the same studio recording with you for this episode.
It is. It's always nice that we can get together. We're here at the Dow Jones Global Compliance Symposium, taking a break and ignoring whoever it is that's speaking right now to come up and do episode 34. We had started this before. I know 33 took us 4 times. I hope that this will take us less than that. So it is, one of the subjects that we heard just now, actually, with Ashley Watson from Hewlett Packard and Jay Martin from Baker Hughes and that other guy from DHL, James Min. They were talking about changes to the FCPA. We were both sitting right next to Mike Kaler, the FCPA professor, who might have some ideas on that himself. But I think that it would be worth it for us, and really to steal your idea, for us to have an episode just to talk about potential changes to the FCPA.
Right.
So let's start with the question of whether or not the Department of Justice, as we often hear, is being overly aggressive. Do you think that the DOJ is being overly aggressive in its enforcement of the FCPA?
Well, Howard, on that, we've kicked that around tangentially through a lot of our episodes over the past nearly a year now, and I've never felt like the department was overly aggressive, and I still don't feel like that now. They made clearly some missteps over the past year in trials against individuals, and we've discussed those at fairly detailed length. And I think what we discovered was the jury doesn't like undercover sting operations and otherwise legal business operations. Prosecutorial misconduct will get your case thrown out anytime, anywhere, if the judge finds those facts to be true. And sometimes you land in the wrong court. And that's just, judges are human, and they bring their own proclivities and prejudices to the bench, just like we do as counselors. So those missteps aside, I don't think we'll see too many more sting operations. That would surprise me if we see any of those coming up. But in terms of aggressive enforcement against companies, I think that will continue. But I don't see overly aggressive enforcement. And we have discussed, and certainly others have discussed, what they believe are either they call it nitpicking or picayune, or matters where a company's Watchwater was the example brought up yesterday, 1% of a company's overall business, and yet there was a FCPA violation. But for me, the key there was it was a SEC books and records. It was not a criminal violation. They did not plead guilty in the form of a deferred prosecution agreement to any criminal actions. It was books and records, and they simply didn't keep their books and records accurately. And the chief compliance officer from Microsoft spoke this morning, and he said, and he talked about it in the context of Dodd-Frank, which was Dodd-Frank is here for financial integrity, and books and records are a financial integrity issue, and it's separate and apart from paying a bribe. And if a company doesn't keep its books and records in a manner that accurately reflects its financial transactions, that's a violation of SEC law incorporated into the FCPA for that purpose. It's a civil penalty, a civil violation, a fine is paid, profit disgorgement. So in cases where people talk about overly aggressive enforcement, I don't think they're talking about criminal violations. I think they're talking about SEC violations. But once again, they're civil penalties, and it's for a different type of act and to cure a different wrong.
Yeah, I was a little surprised actually that Watchwater was really brought up as the example based on the question that was asked, which that was my question. Yeah, I was a little surprised because Watchwater, first of all, it's not a DOJ case, right? It's an SEC case. But also, this is something that I've gone into with Professor Kaler a number of times. I don't know of the case where you can really say it's a rogue employee. This was brought up as the example of respondeat superior run amok, right? A minor functionary in a far-flung subsidiary violates the FCPA, and the parent company now has to unfairly settle with a DPA or an NPA. And Watchwater, that was a situation where the person in China told the parent company, no, you may not see the policy. I am not going to translate it from Chinese. And for whatever length of time, that seemed to be okay to the parent company, which tells me that there was something wrong in the parent company that needed fixing.
Right.
I think that the department, the enforcement record of the department, in my mind, does not fairly show an overly aggressive enforcement program. It is not pushing the bounds of the law to really any extent. For all the sturm and drang about the government official and who's a government official, they haven't charged people that aren't. The closest I think they might have come is on the public hospital surgeons. And that's the Biomet case. That was the Smith and Nephew case before that. I could almost see an argument that surgeons in public hospitals really shouldn't be considered government officials. That's probably as close as I'll come. But I don't think even that is indicative of an overly aggressive enforcement program. They're certainly enforcing the law, but in my mind, it's all straight up the middle. Didn't do due diligence on a third party, and the third party paid a bribe, and the parent company knew about it or gave a wink and a nod. And there were senior members involved. There were country heads or senior vice president of sales or the auditors who were involved. This is the kind of thing that tells me that it's not overly aggressive. It might be aggressive enforcement. They are enforcing the law. They're enforcing laws that are tangential to the FCPA but aren't FCPA. Like the Travel Act and the money laundering laws, and we've discussed that. Whether that's a legitimate exercise of prosecutorial discretion. I think probably it is. I have my reservations, but on the whole, I think that's fair game. If you violate the Travel Act, it's on Congress to change it if they don't like it. But I just don't. I don't see the enforcement record bearing out the overly aggressive nature that people are bandying about.
And the other case that I occasionally hear reference to is Sharing Plow, which was the charitable donation case in Poland, where a governmental official in the form of a hospital administrator directed Sharing Plow to make a donation to his charity for renovations of a Polish ancient castle. And once again, it was not a criminal enforcement action. It was a books and records, because Sharing Plow, who did not routinely make such donations, made a donation but disguised it as marketing expenses. So it's clearly not properly characterized as either a charitable donation or something else, claiming it was marketing expenses. So once again, a civil violation, books and records focused on remedying a different problem.
Yeah, and I hear the point when it comes to the SEC because there's no knowledge requirement. Right, so there's no corrupt intent necessary. If the books and records are wrong, they're wrong. So I kind of hear the argument a little better when it comes to the SEC. But you're right. There's a difference because your liberty isn't at stake. Nobody's going to jail because of an FCPA because of a books and records violation. At least not without some sort of majorly corrupt intent that the DOJ says, oh my gosh, we have to prosecute this as a criminal matter. But certainly in SEC action, nobody's going to jail. And it's a civil penalty against the person or against who makes or causes the incorrect entry, or against the company. So I hear it. I don't think the SEC is being overly aggressive. I think that they have a statute that doesn't require knowledge and they use it, but even that I don't think they're being overly aggressive. So I don't see the desperate need to change and to reevaluate the FCPA simply because the DOJ is being overly aggressive and pushing the bounds of the law. I just don't see it.
One thing I don't think we've really even touched on is if there was overly aggressive enforcement. How might, what reform could be brought into the statute to cut that back? Isn't that really just a prosecutor's call? I mean, Congress can't direct the department not to prosecute under the full extent of the law, can they?
No, and that's right. And I think that, you know, Congress can, I think if they wanted to blunt the DOJ's enforcement, they would have to do things like, you know, limit successor liability. I mean, that I think is a real way. If you want to limit it, you know, after you know, mergers and acquisitions. You know, that would significantly limit the department's ability to or the types of cases that the department wants to bring. But I think if you really want to do it right, you first have to identify the areas in which the government is overreaching and limit those areas. So if you think that the government is prosecuting against people that aren't really government officials, then you limit the definition of a government official. If you think that they are prosecuting, you know, respondeat superior cases that they shouldn't, then you limit the application of respondeat superior in the statute. You know, so I think that that's the way to go. I just don't know, based on the enforcement record, the actual enforcement record, I don't know really any times when they've really pushed the matter. So we'll move on to the next subject. Because we're on YouTube, we're going to have to end one video and start another. So let me do that now.